Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. Sell versus agreement to sell. Transfer of ownership. In sale, the ownership passes from seller to buyer immediately at the time of formation of contract of sale. In agreement to sell, the ownership passes from seller to buyer subsequent to formation of contract of sale. Ownership passes at a future date or on fulfillment of some conditions specified in the contract. Risk of loss of goods. In sale, the goods are at the risk of the buyer. In agreement to sell, the goods are at the risk of the seller. The risk passes to buyer when agreement to sell becomes a sale. Remedies of buyer. In sale, the buyer has the legal right to obtain the possession of the goods. In agreement to sell, the buyer may claim damages for non-performance of the contract. However, the court may allow specific performance of the contract considering the facts and circumstances of the case and the provisions of Specific Relief Act. Remedies of seller. In sale, the seller has the legal right to sue the buyer for recovery of price of goods. In agreement to sell, the seller cannot sue the buyer for recovery of price of goods, but he can claim damages. Right of seller to resell the goods. In sale, the ownership of goods passes on to the buyer, so the seller has no legal rights to resell the goods. However, if the possession of the goods remain with the seller may resell the goods to a new buyer. If the new buyer knows that the seller has no legal right to resell the goods, he does not become the owner of such goods. But if the new buyer was not aware, he will become the owner of such goods. In agreement to sell, the seller should not resell such goods. However, if the seller resells the goods to a new buyer, the new buyer will become the owner of such goods, even if the new buyer was aware of the original agreement to sell. Insolvency of buyer. In sale, the insolvency of buyer, the official assignee shall have a right over the goods. However, the seller may exercise his right of lien if the possession of the goods is with him, else he can get rateable dividend from official assignee of the buyer. In agreement to sell, on insolvency of buyer, the official assignee shall have no rights over the goods. Official assignee does not get the right over goods even if the buyer has paid for the goods. Insolvency of seller. In sale, on insolvency of seller, the buyer, being the owner, is entitled to recover the goods from the official receiver. In agreement to sell, on insolvency of seller, the buyer who has paid the price can only claim a rateable dividend. As the buyer becomes a creditor, the buyer may get rateable dividend of the price paid from official receiver of seller, but not the goods, because property in goods has not yet passed to him. Nature of rights. In sale, the buyer gets the rights against the whole world, that is just in rem. In agreement to sell, the buyer gets the rights only against the seller, that is just in personam. Performance. Performance of sale is absolute and without any conditions. In agreement to sell, performance is conditional and is to be made in future. Type of goods. Sale is made only on existing and specific goods. An agreement to sell is normally made on future and contingent goods, although in some cases may be made on unascertained existing goods also. Type of contract. Sale may be an executed contract. In agreement to sell is an executory contract. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.